My name is Marty Johannes, and I'm the Careers and Personal Finance Librarian for Johnson County Library. And today we are oh so fortunate to have Alexandra English presenting for us. Alex is the managing attorney for Kansas Legal Services and the statewide director of the Kansas Legal Services Elder Rights Project. Also, this past summer, Governor Kelly appointed Alex to be a member of the Board of Adult Care Home Administrators. Alex has found that her days spent working with her senior citizen clients are her most enjoyable ones, and she feels a connection to this group of clients and finds it rewarding to work with them. Alex has been with Kansas Legal Services for 12 years. In addition to handling cases for senior citizens, Alex also regularly handles bankruptcies, protection from abuse and protection from stalking cases, divorces, and paternity cases. Alex is licensed to practice law in Kansas and Missouri. Alex earned her law degree from the University of Kansas School of Law and her undergraduate degree from Kansas State University. During the presentation, as questions come to mind, please submit them via chat, and we'll have some time for Q&A at the end of the program. And I do want to point out that the program is being recorded. And now I'm going to turn the program over to Alex. Alex?
Hi, thanks, Marty. Remind me, I have until 3:30, is that right?
Correct.
And that includes questions at the end?
Yes.
Okay, thanks so much. I hope everybody can see my screen. I have to try and figure out how to make it bigger, I suppose. Here we go. Here we go. Okay. Thank you for letting me join you. I give a lot of presentations like this. My preferred way to give a presentation is in person, in front of a group of people where I can see their facial expressions and have immediate feedback. So I can't see any of you. I hope that this goes okay. I hope if you do have questions, put them in the chat box and I'll try and get to those at the end. Okay. This is just special language I have to include because I work on a grant. So it's a Victims of Crime Act grant. Let's talk about kind of what our objectives are for the day. So first of all, I'm going to go through the Kansas elder abuse statutes and laws. And then we will talk about all of the different following types of documents: powers of attorney, guardianships, conservatorship, trusts, last wills and testament, and transfer on death deeds. And I'll talk about each one of those individually, what they are, define them, and then I will also talk about how they interact with the Kansas elder abuse statute. Then we'll talk about what the responsibilities are of the people that you would appoint as your agents in those documents, and what can be done when an agent doesn't do their job. Is that a criminal act? And then also what Kansas Legal Services can do and how we can help. And then we'll have the question and answer period. Okay, so the very first time that Kansas had an elder abuse statute was July 1st, 2014. This statute is a different version than what we have today. It was updated again in 2018, and the 2018 version is much more all-encompassing. For example, the first version of the statute, the age of a senior was defined as 70. Well, that's been lowered to comply with what other states are to 60. I think that's coming up here in a second. So if you guys got a copy of this, you should be able to click straight to the links throughout this presentation to go to the statutes and read the law if that's something that you want to do. Okay, so yes, 2018, the definition of an elder person means a person 60 years of age or older. So I guess let's actually go to this elder abuse statute. And I hope you'll be able to see it. I don't know. Maybe not, but let me just kind of go through the highlights of it really quickly. It's statute 215417. It's a criminal statute, mistreatment of a dependent adult or mistreatment of an elder person. So this covers anyone, whether they are in a nursing home because they're under the age of 60 but permanently disabled of some kind, dependent on others, or if they're over the age of 60 and living at home. All of these groups would be covered. It can be physical abuse, infliction of physical injury, unreasonable confinement, like keeping people strapped down to a bed, that could be considered unreasonable confinement, or unreasonable punishment upon a dependent adult or an elder person. It can also be taking personal property or financial resources of a dependent adult or an elder person. Undue influence, coercion, harassment, duress, deception, false representation, false pretense. So I use this one a lot, or I see this one a lot when I see family members who try and get my clients to sign property over to them. And it's done under an act of undue influence or duress. I've had blind clients before who've been forced to sign things that they don't know what they are. And at the end of the day, they find out that they signed their house over to a grandson who then takes over every aspect of their lives. A violation of the Kansas Power of Attorney Act. And so we're going to get into what powers of attorney are in just a minute. Violation of the Kansas Uniform Trust Code. Violation of the act for obtaining a guardian or conservator. We're going to talk about guardianships today and conservatorships. The omission or deprivation of treatment, goods, or services. So this would be like a neglect type of a situation where somebody is deprived of treatment. And so, you know, as you can see, this includes physical, this includes financial, it could include mental when you talk about the undue influence and coercion and deception. And, you know, there are different categories of penalty. However, most of them look to be felonies. And it depends on how much money is stolen as to how much jail time a person faces. So that's a summary of the statute. And I will move along, but again, you can click on the link if you want to go see. Okay, so now let's start talking about the different types of documents that exist. A power of attorney document is a document in which the principal gives authority, and I'm sorry, I'm looking to the side because I have another screen to my side. It's a document in which the principal gives authority to an attorney in fact to make decisions and act on the principal's behalf. So let's talk a little bit about what that means and the definitions. The principal in a power of attorney document is the person who signs the document. It's the person whose document it is. And the attorney in fact is who has been given authority. One of Marty's attachments that she sent out today it's kind of like a spreadsheet, and it goes through and it shows all of the different documents we're going to talk about, all of the relevant statutes, and then also talks about different definitions for who drafted the document and what that's called in a power of attorney versus a will. For example, in a will, the person who writes the will is called the testator. And so power of attorney, that person is the principal. So because of all of these different definitions that we're going to go through very quickly, I tried to make this chart. I actually made it for my law students because I have a lot of interns that come through our office. And so hopefully it can help you though too. And again, it should have links to the statutes. So I hope that's helpful to you. Okay, so in order for a power of attorney to be signed, the principal, the person whose document it is, must be competent. They have to have legal capacity to sign that document. When looking at whether a power of attorney is valid, it's important to know that the principal must have been competent to sign the document. And what does that mean? When I'm signing a power of attorney with a client, I'm going to ask, do you know where you are? Do you know who you are? What day is it? Why are you here? Who's the president of the United States? Those are the types of questions that I ask. And I've had to tell people right on the spot before, I'm sorry, but I don't think that you have capacity, or I don't think that the person you're here with, has capacity to sign this document. For example, one time I asked my client if she weren't able to make decisions for herself, who she would want to make those decisions for her. And she was there with her sister, I think. And her response was, my daddy in heaven. So unfortunately, I couldn't let her sign that power of attorney that day. She did not have capacity. It's important to note that capacity is something that can change throughout the course of a day even. I don't know if you guys have heard, sometimes seniors will get a urinary tract infection, and urinary tract infections in a senior can cause actually really extreme mental changes and aggressiveness. And so somebody who's in the height of a urinary tract infection probably shouldn't be signing a power of attorney if it has those types of side effects on them. But they'll get antibiotics, they'll get better, and then later they can sign a power of attorney. If we're dealing with a disease like Alzheimer's or dementia that's very slow progressing, some days are okay, some days are not. Sometimes they have what we call sundowners, where they tend to get more confused when the sun goes down. And so maybe morning is the best time to make sure that someone with questionable capacity is signing their documents. Maybe that's when they're most clear. So it really depends on the person, the medical condition, and the situation. Things to look about later to determine if there was competency. Maybe a doctor's statement regarding competency or dementia about the time or prior to the time that a power of attorney was signed. Sometimes if I question a client's capacity, I will require them to bring me a doctor's statement that says that they have legal capacity. As attorneys, we do our best to make those legal judgments, but if you think about it, there are always going to be family members probably who want to fight things. They want to try and get control of assets. And if I ever think it's going to be a situation like that, and it's at all questionable whether my client has capacity, for sure, I am going to ask for that doctor's statement, because otherwise, as the attorney, you can get in trouble. Most attorneys are good ones, and most attorneys won't let someone without capacity sign a document. But I can't say that I've never seen bad things happen before where an attorney will let it slip through. Or maybe they just faked it really well at the time that they signed the document. So the other thing is that powers of attorney require a notary signature or 2 witnesses. So you can always track down those people to see, did this person have capacity? Do they remember any details? Also, notes or interviews of any other professionals who interacted with the senior about the time that the document was signed. So was Adult Protective Services involved? Was there a home health care agency involved? Something like that. And I'm telling you this because A, it helps you prepare for yourself, but also if you're a caregiver of someone else, it lets you know, okay, how do I make sure this person's being taken care of? How do I, if someone else has taken advantage of them, what kinds of evidence can I look to determine that? And what will authorities look to? Okay. There are several different types of powers of attorney. The first two main distinct ones are a healthcare power of attorney and a financial power of attorney. So these two documents could be all together in one, or they could be separated. Usually at Kansas Legal Services, we combine them into one unless we determine that someone, a principal, wants to make one child who's a nurse the healthcare power of attorney and a different child who's an accountant the financial power of attorney. If you've got two different powers of attorney or two different agents, attorneys in fact, then you're going to want to have two documents probably. Otherwise, it could be just as efficient to combine them. And you have to read to determine which one of these documents it is. So sometimes I have a family member contact me and say, hey, I'm mom's power of attorney. What can you tell me about, Medicaid or qualifying for a Social Security or something to that effect? And if I look at their power of attorney, I have to read it. And if it only says healthcare, then I'm sorry, I can't talk to you because you only have healthcare power of attorney, and I need to talk to somebody who has financial power of attorney. And I have some clients who their finances are so private to them that they will not sign a financial power of attorney. Whereas they're okay saying healthcare wise, yeah, I want my daughter to make all those decisions, but financially, they don't want to name anybody because they don't want anybody to take control. And we'll talk later about what happens if a situation occurs where nobody ever signed a power of attorney. We'll get there. I also listed out what the statute numbers are. I don't think you really need to go through those, but if you're ever curious, that's where they are, and you could click on the link right here. It's also important to note that, as I went through earlier, it is a criminal act under the Kansas Elder Abuse Statute to violate the Kansas Power of Attorney Act. But that is only for finances. That does not include healthcare. Okay. But I think that also makes sense because you're more able to take advantage of someone financially through that financial power of attorney. If you are a caregiver and you're a healthcare power of attorney and you are physically abusing or neglecting, that's part of the statute itself. You don't need it to be covered under the power of attorney portion because physical abuse or neglect are already part of the elder abuse statute. Okay. Two other kinds of powers of attorney are durable versus a non-durable power of attorney. A durable power of attorney stays in effect even after a principal becomes incapacitated. And so when people are talking about estate planning and powers of attorney, that's the main kind that they're talking about, is a durable power of attorney. So you can have a durable power of attorney for healthcare and finances. A non-durable power of attorney is one that is only for a short specific period of time or purpose. So for example, suppose that you were going to go on vacation, and while you were on vacation, it was supposed to be the closing of the sale of your house. So you may need to name a temporary agent and a temporary power of attorney to sign off on all the closing documents. That's an example of when someone might use a temporary power of attorney. But again, for those estate planning purposes, we're talking about durable. And you have to read the language to make sure that that's what you have. Sometimes you can see it right up there in the top title of the document, durable power of attorney. Sometimes the title doesn't say it, but it should also say it in the text of the document. So this is our paragraph that talks about powers of attorney, or that talks about whether it's durable or not durable. And the highlighted portion here, it says, this is a durable powers of attorney, and the authority of my attorney in fact, when effective, shall not terminate or be void or voidable if I am or become disabled, or in the event of later uncertainty as to whether I am dead or alive. So, every attorney's documents are going to look a little different. This is close to the top of our documents, but some attorneys may have it in a different spot. But that's the type of language that you're going to be looking for to make sure that you have a durable power of attorney. Okay. Another thing of note is that you can have a springing power of attorney, or one that only goes into effect, let me reverse that. A springing power of attorney that only springs into effect upon disability versus one that goes into effect as of the date of signing. There are pros and cons to each of those. My general advice is that if you trust the person who you're choosing to be your power of attorney, your agent, then you should check the one that is effective now, effective automatically upon signing. But let's also clarify, you should never choose someone to be your power of attorney unless you trust them. If you have any question that they're going to misuse your money or take advantage of you, find someone else. Sometimes not every person's kid is the appropriate person to be the agent. Maybe it's a neighbor, maybe it's a lifelong friend, who knows? But I just spend a lot of my time seeing kids and grandkids take advantage of my clients. So that said, that warning in mind, otherwise, for practical purposes, it's a lot easier to have a power of attorney go into effect right off the bat rather than have it be determined later at incapacity. Because what could happen, there could be a slow progressing disease like Alzheimer's or dementia. And we talked earlier about how people can kind of go in and out of capacity during that point. So at what point is a doctor going to say that you are incapacitated when maybe you're still going back into having capacity? And during that time where it's unclear, a lot of things are going to get missed. Bills are probably not going to get paid. People who have control of their own finances and don't have someone else watching out are more apt to get themselves involved in scams. So that's why I say it's probably better to have it go into effect right away. I have clients who don't trust anybody and they will only sign one if it's effective upon disability. And if that's all that I can get my client to agree to, then that's what I'm going to do because that's their wish. It's better to have a power of attorney than to not have one at all, even if that means that it is only springing into effect upon disability. Every single person over the age of 18 years old should have a power of attorney document. And I know that's probably news to a lot of you, but if you think about those old cases from the 80s, like Nancy Cruzan, I think that was a Missouri case, and Terry Schiavo, that was a Florida case, that may have been in the 90s. But if powers of attorney had been drafted in either one of those cases, then wishes would have been known right off the bat, or there would have been somebody designated to make decisions. Sorry, we'll see how well I get through this next hour. So if Terry Schiavo had designated her parents over her husband to make decisions for her, then they wouldn't have spent years battling that out in court. It's also important to know that just because you're married to someone does not give you any authority to make decisions for that person. So there is no such thing as a legal right of next of kin because you're married or because you're a child. Doctors may sometimes let things slip through, but for the most part, if there's no power of attorney, then you're probably going to have to get a guardianship, and we will talk about that soon. Okay, I included the language here so you could see it. So the language you're going to look for a springing power of attorney says something to this effect. Notwithstanding anything contained herein to the contrary, the authority conferred on this attorney in fact shall become effective only upon subsequent incapacity, disability, or shall continue until the earlier of the following, my death or my revocation. I haven't talked yet about how long a power of attorney lasts, but that it's in that paragraph there. Unless there's a specific end date on it, it terminates upon death. Or if you can always revoke it as long as you have capacity to do so. And this is one that goes into effect right away as of the date of signing. The language is going to look something like this. The rights, powers, and authority of my attorney in fact shall commence and be in full force and effect on the date of the execution of this instrument, and shall be in effect until death or revocation. This powers of attorney document shall not terminate upon my subsequent incapacity or disability. So it's pretty clear, I think. Okay, sorry, I'm getting immense. Hopefully I'll still be able to talk. Okay, so when does a power of attorney terminate? I guess I just talked about that. Upon revocation, so you can always revoke your power of attorney. First of all, you would do that by signing a new document, a new power of attorney. So when you sign a newer version, it automatically revokes the older one. And then the agent can resign. And I've seen that happen before. You can choose however many people that you want to be your agent, but in my mind, it's better to choose one person with an alternate. Some people think, oh, I need to choose all 3 of my children and give them equal powers. Well, guess what you're doing? You're setting everybody up for a big fight. So sometimes it's just best to choose one person. And I've seen my clients resign as an agent for their parents when they get into disputes with other siblings. So if it's 2 against 1 and the one person just adamantly believes one thing and the other 2 are against them, it's too much hassle and they don't want to fight. And so they resign. And then upon death, there are 2 exceptions to that death piece. After the power of attorney, or after the principal passes away, the power of attorney, the agent, can pay final burial expenses and also request an autopsy if it's a healthcare power of attorney. And you can see why those 2 things would be important things that need to be taken care of right away, and why the power of attorney is still effective for those 2 pieces. Final burial expenses, the power of attorney can write the check out of the principal's bank account. Also, autopsy, you can understand that might be like, suppose there was some sort of medical neglect or medical negligence, and the power of attorney would be the person left to say, okay, we need to get the autopsy done so that we can, if there are any damages there, we could do a lawsuit of some kind. So it's a big deal to be someone's power of attorney, to be their agent. First of all, record keeping. Suppose that I were my mom's power of attorney and I had to go out and get groceries and pay utilities. First of all, it's going to be really important that I don't commingle that money with my money with my mom's money, because how am I ever going to prove whose money I was using to pay if it's commingled? The exception to that is if a husband chooses a wife to be the power of attorney or vice versa. And if that happens, then they own everything jointly anyway, and that's okay. But I don't recommend joint ownership and commingling of assets if it's anyone other than a husband and wife. Also keeping records and receipts. If I'm my mom's power of attorney and I go buy her groceries and suppose that I use my money to do that and I need to reimburse myself for it, then I need to keep that paper trail of how much money was spent and how much money was reimbursed to me. Or if I use mom's money to buy a new air conditioner for her house, well, then I need to keep the receipt to prove that that's what it was for. Yeah. Okay. So an agent has a fiduciary duty to act in a principal's best interest. A fiduciary duty, I mean, it's legalese, but it means that they have a duty to put the principal's interests above their own. An example that I've seen of this where things have gone wrong before, I had a client who owned real estate in Kansas City, Kansas, and she was moved by her agent down to some family members who lived in the Southeast. I think it was Georgia or something. So she had this house sitting here in Kansas. And in the meantime, while my client was down in Georgia, the power of attorney was letting her own child live in that home rent-free. And that's what I would call self-dealing, because she was giving herself and or her child a financial benefit to the detriment of the principal. And that, you know, that's the crux of what a fiduciary duty is, putting someone else's interest above your own. So, you know, I think there could be a lot of arguments about why that was wrong. There could be an argument that it wasn't so bad because at least somebody was sitting in the house so that it wasn't vacant and there weren't looters or, you know, people vandalizing the home. That's true, but maybe the most appropriate solution would have been a reduced rate of rent. Still, the client would have been entitled to have some rent coming in and then money to live off of. The Kansas elder abuse statute does make a violation of the Kansas Power of Attorney Act a criminal act, and we talked about that. So that's another responsibility of the agent. Also, if you're ever someone's power of attorney, there's a very specific way you should sign your name. It should be your name, comma, POA4, and then you list the principal's name. And that's really important because you are never personally liable for the principal, and vice versa. If you choose your kids to be your agents for you, they're not personally liable for you. They don't have to use their own money to take care of you. But what I've seen happen too, I had a guy who, he was a senior himself, and he was his mom's power of attorney. She was very, very elderly. And he had to put her into a nursing facility. And when he did that, he signed the admission papers under his own name. Instead of saying, you know, John Doe, power of attorney for Jane Doe, he just said John Doe. And that nursing home, even though the client would have otherwise qualified for Medicaid, they were trying to get him to pay that bill. So because they said that he signed under his individual capacity a contract to make payments. So for whatever that's worth, a good piece of advice, whether you are the principal wanting to make sure your kids know how to protect themselves later, or whether you're acting on someone else's behalf. Oh, okay. Oh, sorry, my mitt. Actions that an attorney, in fact, may not legally take. There are just a few things that you cannot do no matter what. You cannot make, publish, declare, amend, or revoke a will or trust for a principal. So that makes sense because you, as the power of attorney, cannot benefit yourself. So it doesn't make sense for you to be able to determine who the principal's beneficiaries are, because it's just so ripe for wrongdoing. You can't make, execute, modify, or revoke a living will for the principal. We'll talk about what that is in a minute. Or a do not resuscitate order. You cannot require the principal against the principal's will to take any action or refrain from taking any action. And you also cannot carry out any action specifically forbidden by the principal while not under any disability or incapacity. And I know that can be very vague. Those could be a lot of things. I know you may have a senior that says in your life that says, I never want to go into a nursing facility, and I forbid you from putting me in a nursing facility. Well, that's probably not something that's going to be upheld in court, because sometimes that might be the only place that can care for this person. So for whatever that's worth. Okay. What if there's no power of attorney? If there's no power of attorney and the elderly person has capacity and someone they can trust, there's still time to get that power of attorney drafted and signed. This is a good spot for me to talk about using an attorney. And I know that a lot of people like to do things on their own. There are a lot of services now. There's LegalZoom.com. There are Office Depot. There are forms. You may go to the library and find forms. My best advice, and I mean, they teach us this in law school. We go to law school for a reason. You can get powers of attorney done pretty cheaply. There is no reason why you shouldn't use an attorney, because you may have some special facts, some special thing about your situation that if you are using the Office Depot form or a LegalZoom form, either you haven't been able to get the proper advice about what should be done for your personal situation, or maybe you're using a wrong form. What's legal in different states may not be legal in Kansas. We have very specific rules about how you sign a power of attorney, and you have to have it notarized or have 2 witnesses. And some states may do that differently. So you want to make sure that you have a licensed Kansas attorney draft your paperwork. That does not just apply to powers of attorney. I'm talking about all of your documents. What if there is no power of attorney and there are concerns about competence? So the only solution is what we call a guardianship or conservatorship. A guardianship is when the probate court determines that the ward is an adult in need of an impairment and appoints a guardian to make mostly health-related decisions about the ward. Basically, the court appoints someone, and it can be someone who has already petitioned the court for the ability to make decisions about the ward. Again, this is a situation where you're going to want to look back at that chart that Marty attached to your email, because the chart gives the definition of a ward, or it talks about ward and conservator and guardianships and all that. So that'll help make some sense of the definitions here. Guardianships are really for healthcare issues, and anybody with an estate under $10,000. So if we're talking somebody who's only making Social Security, they're never going to have $10,000 at one time if they're, no assets, living off of Social Security. It's going to be a guardianship instead of a conservatorship. It's when you get over $10,000, that's when you also have to have a conservatorship. So big difference between power of attorney with an agent and a guardianship and conservatorship is that all guardians and conservators are required to file an annual report with the probate court accounting for all of the funds that were spent during the year. And also for the healthcare portion of that, it would be how the health of the ward has gone for the past year. This is where you can click and you can go to the statute, but I also listed it out here. These are the general responsibilities of a guardian. So if the ward is a minor, have the custody and control of the minor and provide for the minor's care. You may wonder, like, why would the ward be a minor if we're talking about seniors and adults? Well, sometimes in life now these days, we have a lot of situations where parents are not the ones raising their children. Maybe it's a grandparent. Maybe it's an aunt or an uncle or an older sibling who is an adult. So that's why you would have a guardianship over a minor. But then there's the option here, if the ward is an adult, take charge of the person and provide for the ward's care, treatment, habilitation, education, support, and maintenance. Again, that one is, sorry, lost my train of thought for a second. That is not a requirement that you spend your own personal money as the guardian. You just have to make sure that you use the resources of the person who you're caring for, the ward. You have the duty to consider and either provide on behalf of the ward necessary or required consents or refuse the same, to assure that the ward resides in the least restrictive setting appropriate for the needs of the ward, which is reasonably available. So if you have someone who is, I don't know, 73 years old in pretty decent health, but maybe is just having a hard time doing things around the house, just can't get the lawn mowed, things like that. I would say it would be unreasonable to go from having that person live at home by themselves to all the way up to full care in a psychiatric unit. That doesn't make sense at all, because that's not the least restrictive setting. The least restrictive setting is probably like, hey, let's talk now about assisted living, or maybe a senior living community with apartments or something to that effect. We don't go from step 1 to step 9 right off the bat. And in fact, I do think there are some rules with guardianships about not having people go into mental facilities, which is why when you've got somebody with a mental illness who you love, it's so hard, because sometimes even the guardianship solution won't work. To assure that the ward receives any necessary and reasonably available medical care, so you got to make sure they're taken care of. To promote and protect the comfort, safety, health, and welfare of the ward. To make necessary determinations and arrangements for and give the necessary consents upon funeral arrangements, burial or cremation, autopsy. Again, these are kind of the same things that you saw with the power of attorney, because as soon as somebody passes away, those are things that need to be done right off the bat. Conservators, honestly, I think that might be too small for me to see where I am, but it's very similar, except that it is maintaining assets instead of health. So it's making sure that money is spent appropriately and that you keep track, records, that you, for example, I see one right here, to sell the assets of the conservatee's estate when the interests of the conservatee or conservatee's estate require the sale thereof. So if it's in the interest for a house to be sold, because that would then get the conservatee, again, we're going back to our language and look at that chart, but that instead of saying ward with a conservator, with a guardianship, you say conservatee with a conservatorship. So just make sure you're doing what's in the best financial interests of the person that you are the conservator for. A trust. So trust documents or trust statutes are here. You can click there. I'm going to tell you right off the bat, Kansas Legal Services We handle most of everything that I've talked about, but we do not draft trusts. And I'll kind of explain why, but just know that these are things that I've read through before. I've read people's trusts. I took classes on trusts in law school, but this is not my area of expertise because most of our clients are low income and are not needing a trust. So a trust is a legal document that transfers the current ownership of the settler's property from the settlor to the trust. Okay, look at your chart because the settlor is going to be equivalent to the principal in a power of attorney or the testator of an estate of a will. So again, look, that definition is really important, that language. So basically you're transferring ownership. If you're getting a trust, you are transferring ownership of your property from your name into your trust's name. So you no longer own your house, your trust owns your house. So why would people want to do that? Well, there would be some pros if you had lots of money, like multimillionaire, there would be some tax benefit to that. Also, the benefit is that it avoids probate court. I think I've got slides about that coming up, but I'll hit that in just a second. So if you create the trust, you are the settlor and you appoint a trustee. You can be the trustee of your own trust, or you can choose a third party. Often what happens is you say, okay, I'm going to be the trustee of my own trust for as long as I have capacity, for as long as I'm able to. But then when I don't have capacity any longer, it's going to go to the authority of the backup trustee. It gives the trustee legal authority over the assets in the trust. But I would also say this makes it ripe for theft and self-dealing. I think you can see how this could happen if the trustee steps in and starts taking over, especially if the settlor of the trust is still alive. Or the beneficiary. I've had a client before who, for example, her parents left her as the beneficiary of the trust, the family farm. And the brother was the farmer of the farm. And he was the trustee after the parents had died, and the sister was the beneficiary. Well, the brother comes in and starts charging the sister because he's farming the land and he's making her pay all these fees because technically she's the beneficiary of this trust. So I think you can see there are opportunities where things could maybe not go so well. Again, very similar duties. I've just listed them out here. I actually cut and pasted this from the statute. But a duty of loyalty, a duty to administer the trust, duty to collect trust property, duty of discretionary powers, trustees' skills. That one's kind of interesting. It talks about if you are, suppose you're an investor. If you are an investor, you have extra liability above and beyond what that of a layperson would be to prudently spend and invest the assets. If you're an attorney, you have a higher standard. Also, this is one that the elder abuse statute makes a violation of the Kansas Uniform Trust Code a criminal act. So I guess I don't have a slide in there about the pros and cons and things like that, but basically with a trust, we recommend that if you are a multimillionaire or you have a disabled child in your life, then you might consider a trust. I've seen it work really well for disabled people. I had a couple of disabled twins, and I think that I can't remember what their disability was, but they came in to see me together, and they were the beneficiary of their mother's special needs trust. And This trust owned the house and protected it for them for their whole lives. And the benefit of that was they still got to receive their Social Security and Medicaid benefits. A lot of times if you have an income or there are other assets available to you, then you can't also get government benefits. But they were able to collect their benefits, their Social Security, and still live in that house, and it was protected for them forever. So there are really good reasons for trusts. But I can give you other alternatives to probate that we'll talk about towards the end that I think will be a better solution. Because if you don't have millions of dollars, I've also seen situations where, say you have $20,000. Well, you go to some presentation by some attorney who's trying to get as many new clients as they can, and they tell you you need a trust. You only have $20,000 to your name. You do not need a trust, and there are a lot better ways, cheaper ways to avoid probate court. Because what will happen is you'll then spend that money quite quickly. $20,000, of course, is nothing, and you'll go through that very quickly. And then at that point, you'll be broke, but you have a trust, and so that's going to prevent you from getting Medicaid assistance. So if you do decide that you want a trust, I really want you to ask around, find a couple of attorneys, and make sure, here's the litmus test. Make sure that the attorney that you go to understands Medicaid implications as they relate to trusts, because you don't want somebody who doesn't understand how those two things interact. Again, my office does not draft these trusts. A will. Okay, so let's talk about what a will is. Look at your chart that you've got, because we have new vocabulary again. A last will and testament is a document in which the testator expresses their intent of who gets what property when the testator passes, who the executor is, who is tasked with probating the estate, and what the testator's final burial wishes are. A will does not give anyone any current authority over the testator's property. So I do like that about a will, in that someone else cannot come in while you're still alive and take your stuff just because you named them as a beneficiary. But a will does not avoid probate court. So that's really important to know. You think you're doing everything you need to do for estate planning purposes, and there are so many different considerations. It's very likely that you need a will in addition to several other documents. So the executor is the person who handles everything. The testator would be you, the person who makes the will. Also, there's no such thing as a joint will with a husband and a wife. I've seen people ask about that a few times over the years. I don't know if other states do that, but I know that that is not a Kansas thing. So each individual person has to have their own will. Even if you go to a private attorney and have a trust drafted, there probably will still be a will. It's called a pour over will. So if you're going to have a trust drafted, you're going to have a complex enough estate that you need all of these multiple documents for all of these what if situations. I've also seen where my clients don't really have much. We can deal with their real estate in some other way to avoid probate, but they have some specific burial wish. I know that I had a client whose daughter, I think, was a Jehovah's Witness. And I don't remember what the burial practices were for Jehovah's Witnesses, but whatever it was, my client wasn't having it. And so my client said, I need this will because I need to make sure that the way I want to be buried happens versus what my daughter would want to do for me based on her religion. Okay, transfer on death deed. This is a great way to avoid probate court for your real estate. any and all real estate that you own in the state of Kansas, you need a transfer on death deed for. This is a document that the owner of the real estate transfers ownership of said real estate to a grantee beneficiary upon the death of the owner. It must be recorded with the Recorder of Deeds office for it to be considered effective prior to the death of the owner. So it gives no current ownership interest. It avoids probate court, but that it says that, you know, if I die while I own this house, I want this house to go to so-and-so, or maybe I want to divide it up among my 3 children, whatever the case may be. But it does avoid probate for that real estate. If you own 2 pieces of property, you need 2 transfer on death deeds. It does not cover other kinds of property. And so, hang on, let me see what my next slide is. Okay, so I'll talk about the other kinds of property right now, but I don't have slides about them. So that's for real estate. And then you're gonna have your bank accounts. So for your bank accounts, you should be able to go to the bank and do a POD, pay on death, on each and every one of your accounts. If you're talking about money, it's going to be POD, pay on death. That again does the same effect as a transfer on death deed. I think when you do that, you have to take the name and the social security number of the person that you choose to make your decisions for you. Or I'm sorry, the person that you choose to receive your money after you die from your bank accounts. And you would need each and every account that you have needs to have a POD listed. On a car, you would do a TOD, transfer on death, and that gets filed with the motor vehicle department. And it just says that upon my death, I want my car to go to so-and-so. I know that that seems silly in a car. Oh, it can only be worth so much. Maybe some cars are only worth $1,000 or so. But I will tell you that because a car is a titled piece of property, that's something that you really, it's important that you name somebody to get your car so that even if all they do is sell it, they have the ability to do that. Otherwise, they've got to go and file all kinds of affidavits and stuff. So this is really the best way. If you've got life insurance, of course, you add beneficiaries to the life insurance policies. I think that really just leaves your personal property left. And so your personal property, assuming it's under $40,000 and nobody's fighting over it, it's not going to go to court. So I think that's, you know, if you want to have a will to go along with these things, and then with the will, you can legally designate who gets what of your personal property if that's important to you. And sometimes what I've noticed is my clients who have you know, fewer bank accounts and fewer financial resources, it is those personal property things that are the most important to them. And so I understand that. And a will would absolutely be a good reason to get a last will and testament for that personal property. But again, unless it's over $40,000 or unless people are just outright fighting over it, you don't need to go to probate for it. Okay, so if you yourself realize that you are being taken advantage of, whether it's by your power of attorney, by your guardian, something like that, first look to the statutes. Hopefully you guys can save this and you can see what statutes are being violated. I've found law enforcement sometimes, especially with the new law with the Kansas elder abuse statute, a lot of my clients will take their situations, they'll make their report to law enforcement, and they'll come back and say, oh, that's a civil matter. Johnson County, luckily, has taken this issue very seriously. And I think for the most part, I know the DA's office is very well versed and they are charging people for this elder abuse statute that we have. But a lot of the smaller counties that I cover, the law enforcement for sure, they look at this and they're like, oh, you know, go sue him, whatever. That's why I think these statutes are so important, that you have access to them, because I think it's really important that you take the statute with you. Sometimes you have to educate law enforcement. And if there's law enforcement on here, I'm sorry, I'm not singling you out. I just, I've seen it before where people, I've tried, you know, to argue with law enforcement officers, like, see, you really need to take note of this, but they don't want to hear that. There are some excellent law enforcement officers too who do a really good job of this. There's one in Wyandotte County, KCK Police Department, who specifically focuses on elder abuse too. But the other thing to note about the statutes is that a lot of these statutes refer to other statutes. So it'll say in one statute, all incidents that occur under a different statute number. Well, then you need to go to that other statute number to read the statute. So I know it can be very confusing, and that's why I tried to include all of those links. Okay, how can Kansas Legal Services help? We have 2 grants that are directed at senior citizens. The first and the oldest grant that we have related to seniors is the Area Agency on Aging. Each county gives us a little pot of money, a grant in which we can assist seniors with a whole array of legal issues. And this ranges from just legal advice about maybe landlord-tenant situations or other situations, to actually drafting of powers of attorneys, wills, transfer, and death deeds. That program is pretty popular, and I know that sometimes there are wait lists to get into site visits. Our attorney who does those cases is Tom Lastly, and he does most of those site visits. He is senior attorney himself. He's been practicing estate planning work for over 40 years. He's really good at giving off-the-cuff advice and also doing estate matters. Then the other project, and the goal of that is to at least provide advice. We can't provide representation in all situations under that grant, but we can at least provide advice, a starting point. So you know which way to go. And then again, we do draft all of those documents listed: powers of attorney, wills, transfer, and death deeds. I know I mentioned in passing living wills earlier, and I can go into that just for a second right now because we also draft living wills. Living wills are a document where you get to say what your end of life wishes are. So you say you have a terminal condition. 2 doctors say that any treatment that you get won't affect the outcome. You're terminal. 2 doctors say you're terminal. Then you sign a living will that says that you do not want any life-sustaining treatment. That does not mean that you cannot have comfort care. That does not mean that if you need a surgery to just keep you comfortable, that you won't have that. But it does mean that your life won't be unnecessarily prolonged. That is the only thing that you can do. I know sometimes doctors will listen to family members, but if your family member has a different wish for you than what you have, it's really important that you have that living will, that you say, I don't want to be kept alive in this situation, that you tell your doctors, make sure they have a copy of the living will. I swear one of these days, technology is going to be so advanced, we're all going to have like a little bracelet that has a jump drive that has all of our legal documents on it. It doesn't exist yet, but those are things that if you have a hospital that you would normally go to in an emergency, and your doctor is affiliated with that hospital, go ahead and give them a copy of that so that they can see that in a pinch. Then the other type of document is a do not resuscitate order. That is not something that my office does because it needs to be signed by an attending physician. that do not resuscitate order says even if you don't have a terminal condition. So say you go to the hospital because you have a knee surgery and you code on the table, if you had a DNR, they wouldn't resuscitate you. I think really the purpose of that is for people who are in the very end stage of life. I am someone who I have most of these documents drafted. I don't want to be kept alive unnecessarily, so I have a living will. I know that's a touchy issue. My spouse won't sign one, and that's his choice, and that's fine. But it's just important that if that's your wish, that you have it written down. So whatever that's worth. And I know I don't have a slide about that, but I'm sorry, I just added that at the last second. Okay, the other grant that Kansas Legal Services has for seniors, for anyone 60 or over, is my grant that I work on, and I'm the statewide director of the project. It's the Elder Rights Project. We get money from the state to do victims of crime work. So any senior who's a victim of crime, any kind of crime, then I can come in and help. And I do a lot of physical abuse or intimidation cases, like I do protection from abuse, protection from stalking. I have a case right now that I actually, I don't do this very often. This is the first time I've done this, but I actually filed a lawsuit against someone's relative because they stole money, over $70,000, and I filed a lawsuit. So we'll see how that goes. The crime just has to be alleged. So, you know, if you've made a police report, but maybe the cops tell you, oh, that's a civil issue, but it's something that you've made a police report about, it still may be something that I can help with. So once it's been determined that the elderly individual is a victim of crime, KLS can represent that individual in any issues stemming from the crime. So if you're a victim of crime, but you're being evicted because your abuser failed to pay your rent, then I can get involved in the landlord-tenant case, as well as some cases maybe against the abuser. So there's a whole host of things. We're trying to figure out the best way to deal with scams. Unfortunately, sometimes there are not many options of what I can do. Because I don't have the resources of the FBI, I can direct people to the FBI to make these scam reports, or to the Attorney General. I can help compile information, but I think the biggest thing that I've been able to do for one of my clients who was the victim of a scam is that the scammer was having my client buy iTunes gift cards off the not off the internet, at Walmart, I think it was. And so they were having them take out credit cards, buy iTunes gift cards, and send them overseas. And then they would pretend to make the payment on those cards. So my client would, the payment would like temporarily post and say pending. And my client would go out and take up the whole line of credit again because it looked like the card had been paid. And then the payment would get rejected. And so we're like, 5 times over the credit limit here. And my client has, $50,000 worth of debt. And so I was able to do a bankruptcy for that client, and I got that debt wiped away. So if you think that you have been the victim of a crime and you're a senior, or you know somebody who is, of course there's Adult Protective Services, of course there's the police, but also consider Kansas Legal Services as an option. I've done protection from abuse or stalking. I've done nursing home abuse. I actually did an illegal nursing home eviction case this year during COVID. Civil lawsuits, assistance with a crime victims compensation application. I've done criminal advocacy where, I can't legally represent a victim in court, but what I can do is I can go sit there and I can help hold hands. I don't would say during COVID, not really hold hands, but go be there with you and explain to you the process. I had one client who her home was burglarized and they caught the person. It was somebody that she had let stay with her from church. They were homeless and she let them stay with them. And so they broke into her safe and burglarized her. And I went to every single court hearing with her in the criminal case, including the sentencing, in which she got to read her victim impact statement, and she had me stand up next to her. So that was pretty important. And I think that shows that, you know, I was at least helpful to her and that I gave her encouragement. And that's something I can do. I can do bankruptcies. I can revoke powers of attorney. I can help with divorces and landlord-tenant cases, collection cases, etc. There's really no limit, except that I don't do criminal work, and that, you know, if you're a defendant in a criminal case, I'm certainly not going to represent you. How do you apply for services? So this was drafted before COVID. So just cross off that walk-in right now. We are not taking walk-ins any longer, and hopefully one day, maybe before the end of the year, we'll open back up to that. But we're just at the point where we all came back to the office to work from the office on April 12th. So we're not taking walk-ins, but you can apply online, and also you can call our 1-800 number. So those are the best ways to reach me, meaning to get an application going. For many of you who may apply in the future, the paralegal who works on all of the senior cases, her name is Veronica. And so Veronica works with Tom on the Area Agency on Aging cases, and she works with me on the Victims of Crime Act cases. I also oftentimes have an intern, so sometimes I have my interns reach out to clients too. But those are the people from my office, and if you ever need us, I hope you would apply. And then time for questions and answers.
So the first question is, I'm a trustee over my grandma's trust in Ohio. Am I held to Kansas laws or Ohio laws?
I am pretty sure it would, and again, just so everybody is clear, this is not legal advice. I have to say that. But this is just legal information that I'm giving. But no, I believe it would be Ohio law, and the trust probably should explain which state's laws apply. You know, it's possible there are people who are very wealthy and have homes all over the place. So it's possible for a trust to have been drafted in Kansas, but cover property in California. But I still think it would probably be the Ohio state where law would apply in that situation.
Okay. The next question: if you were to have a trust and bank accounts and cars are listed as assets, do you need a POD and TOD, I believe?
You don't need one. Of course, the trust would then distribute the assets according to your wishes after death and avoid probate court. But I will caution you, if you get a different bank account or if you get a new car, you have to be sure to put the new bank account, put the new car into the trust. Because if I've seen that a lot too, where people have these trusts drafted, but they don't keep up with putting all of their new property in the trust, and then it's pointless.
Okay. Next question. If you do not have a family member to be the executor, how do you find a qualified, dependable person for healthcare and finance? Okay,
so executor would be with a will, and I don't know if the question was directed at a will or a power of attorney. This is, you know, a big problem. I have a lot of clients who need help and don't really have a good person. You know, if you have any community connections, I have a lot of people choose friends from church. But my other story about allowing the homeless person from church to stay in your house may also dissuade you from that. So just, you know, you really have to know what you're doing, who you're choosing, a family friend. There is a company, and if all of my screens weren't filled right now, I would Google it, but it's called Our Care, ARCARE, and I know it's local. And I know that they can do some work where they're paid to come in and help with estates and trusts and things like that. And not the drafting of it, but the executing of it.
Okay. I'm a nurse, and as I've been told in the past, at least in the state of Missouri, during a surgery, when they are changing the patient hemodynamically, a DNR is not in effect. And she was just wondering if that is true in Kansas as well as in Missouri. And apparently the DNR will go back into effect after the patient has recovered.
Okay, I am not 1,000% sure, and I have zero medical background, and I'm not even really sure of what the word hemodynamically means. but you could very well be right, and because you're a nurse, you probably know more than I do to that end. I just legally, that's the explanation I've been given, but I don't know for
sure. Okay, and one last question. Regarding probate, is there a limit to how much in personal property that doesn't transfer with TOD or to beneficiaries the decedent has in order to avoid probate in Kansas? I think you mentioned a figure of $40,000.
Yeah, $40,000 is, there's such a thing as a small estate affidavit, and that's the limit on a small estate affidavit. And so it may still be something that needs to be filed with the court, but it's not, or provided. I've seen it had to be provided to a bank because there's a bank account that doesn't have a POD. But as long as that totals $40,000 or less, then it doesn't have to be fully probated. And also, if any of you ever finds a will for somebody that you know has just recently deceased or even later, in the state of Kansas, anyone who finds a will has a duty to file it. There is a difference between filing it and probating it. So you can just file it to preserve it in case issues come up in the future. But there is that duty that if that will exists, it needs to be put on record with the county, just to preserve it.
Okay. And we got a clarification on what hemodynamically changed means. And it means that the blood and fluid status, which affect blood pressure and heart rate, is what that means.
I appreciate that. I had no idea. So you caught me on that one. Thank you.
Okay. Okay, so I'll ask, we have a few more minutes. Are there any last burning questions that anyone would like to pose to Alex? Okay. And if not, we can go ahead and close. I want to thank you, Alex, for another incredible, awesome presentation. We have had the good fortune to have Alex present at the library for us, probably over the last 10 years or so. And your presentations are always so well received, and we always get such wonderful comments from the patrons about how enlightening they are. So thank you, Alex.
Yeah.
And I'm glad that all of you were also able to join us this afternoon. As I mentioned, the program is being recorded, And the recording will be available on Johnson County Library's YouTube channel. We have a career and finance playlist. It'll be available within the week. You can also access it by going to our website, and under the research pages, we have a personal finance page, and there's an online programs archive on that page. So again, thank you for attending and enjoy the rest of your day.